Hi, welcome to the Law Simplified. I'm Shraveen Bandaranayake. More often than not, a factor that deters prospective students from coming into a law degree, and when it comes to students who are already in a law degree or moving on to their second or third years, a factor that often tends to make them feel frustrated with the qualification that they have chosen and potentially the profession that they are getting into, is the vastness or the enormity of the content that they have to go through. Now, on numerous occasions on this very channel, as well as during my one-on-one masterclasses, students tend to come up constantly and ask me of what material that they should go through, should I be looking at this or that, and so on. Now, I appreciate the fact that when it comes to a law degree, there's a lot that you have the potential of going through. But what's important to understand, and this is something that you might not realize, is that it's not essentially about studying everything or studying hard. As much as anything else in life, it's about studying smart. So this video is an outline and something that I would like you to inculcate into your technique of studying as well, considering the fact that you're going for an articulated argument in your substantive law degree. What I mean by that is, I've always suggested that whenever you approach a law degree, whenever you approach your examinations, make sure that you separate yourself from the pack, separate yourself from everyone else by having an informed opinion, by having conviction of response. Never go for the kitchen sink argument, so to speak. So once and for all, this video is meant to outline what you should study and perhaps what not to study. If we take any law degree or any qualification in law, there are three fundamental elements that you will have to study or to essentially learn and understand. On the one hand, the black letter law, the substantive material, the actual crux or the meat of the subject matter. Secondly, you will have to go through case law or precedent case law that would have provided substantiation for that law or the rationale for such a law to be in place, as well as articulate your own arguments. Thirdly, any commentary or critique on the law which has been provided by academics, jurists, lawyers in terms of their arguments, and even judges in obiter or in their opinion. Now, whatever the type of content that you will come across or whatever the material that you will encounter in your study pack material provided by your university or even online resources that you might want to bring in, they will all fall into one of these three categories, either the substantive law, case law, or critique. Now, the bulk of the content will essentially be in the substantive black letter law. You need to understand what the law is before you supplement it with anything else. But what I've often noticed is that students tend to focus heavily on that secondary component, the case law, by heart in the case names, by heart in the facts of each case, and this can add up quite significantly. For example, if you take a subject like tort law, by and large, the subject itself will require you to have some semblance of an understanding and memory, as much as I hate to admit it, on 150 or so cases, spread across from negligence to vicarious liability to nuisance to occupiers and so on. Similarly, if you take a subject like criminal law, which most of you will encounter in your first year, the aspects in relation to the case law will again be somewhat similar to tort law in the sense that it's quite substantive and it's quite bulky. But what I am suggesting in terms of your approach to study is to work backwards. Determine for yourself what you want to accomplish with this law degree. Are you, on the one hand, trying to show an examiner that you know everything under the sun, in which case you can pass? Or are you trying to better your advocacy or the ability for you to advocate an opinion or an argument? In terms of an examiner, if you go through a number of videos that I have released over time, which you can check out in the links in the description below, you'll notice that an examiner prefers the latter component. the fact that you have conviction, and the fact that you have an opinion or an argument you want to foster. Study each individual topic and understand how exactly it turns. In other words, how it evolves, what is expected from each individual topic. And then bring in the content that will substantiate that particular aspect and your argument that connects to it. Right, this was a very quick outline to give you a heads up on how you need to think about studying, whether you're studying hard or you're studying smart. There are a number of videos that I've planned out to substantively incorporate other techniques that will supplement this particular video, which will come about in the next few weeks. But until the next time that we meet, have fun, stay safe, and obey the law.